Mediation is an alternative to going to court or having a judge decide your eviction case. It can help the landlord and tenant avoid the disadvantages of eviction cases. An eviction case is also known as an unlawful detainer. Mediation can be a very good choice for landlords and tenants who have a dispute. It may help you get a better outcome more quickly and less expensively than the court eviction process. In mediation, both sides meet with a neutral person who is specially trained to help people resolve their disputes. Everyone works together to reach an agreement instead of having the judge or jury make a decision. The mediator will not force you to reach an agreement. Whether you decide to resolve your dispute and how you resolve it is up to you. If you can't settle, you can still have the judge or jury decide. There's nothing to lose by trying mediation, and there is a lot to gain. Whether you are the landlord or the tenant, there are a lot of reasons why it is a good idea to mediate your dispute. Many people are more satisfied with the process and results of mediation than with a court hearing. Eviction trials are difficult to properly handle without a lawyer. You need to know the law and follow the rules of evidence. In mediation, you are not limited by the rules of evidence and other strict legal requirements. Mediation allows you to talk about other issues that may not be directly related to the law, but are very important to you and how you feel about the dispute. Both sides must agree on the outcome in mediation so it is acceptable to all parties involved. These agreements are often more likely to be followed than a decision by a judge. If the landlord and tenant settle the eviction case through mediation with a written settlement agreement, the case usually will not appear on the tenant's credit report, even if the tenant agrees to move out or pay the landlord money. But the agreement may expressly state that the eviction will be reported on the tenant's credit report. Depending on what is important to you, you may settle your eviction disputes in many different ways. For example, you may agree that the tenant may continue to live in the property. The tenant will move out of the property on an agreed date and leave the property in good condition. The tenant will make back rent payments to the landlord. The landlord will make repairs to the property. A judgment will not be entered against the tenant if the tenant complies with the agreement. The eviction case will not appear on the tenant's credit report. You can go to mediation anytime you are having difficulty resolving a dispute. If you are writing a letter to the other side about a problem regarding the property, or sending or responding to an eviction notice, consider asking the other party to mediate the dispute. Some mediators will call the other party for you, explain mediation to them, and encourage them to mediate your dispute. You can ask the other side to mediate your dispute before or after an eviction case is filed. Preparing for a mediation is a lot like preparing for your trial. It is important to identify and organize the facts that are relevant to your dispute and understand the law that applies to your case. Be sure to know about the facts that support the other party, not just those that support you. If you are going to mediation before trial or instead of trial, there are some other things you should do to prepare. Be realistic about how the judge would decide your case if you had to go to court. If possible, talk with a lawyer who can give you advice about how a judge would decide. Think about whether you or the other party is angry or has hurt feelings, and why. Consider what you and the other party would really like to accomplish. Think about whether something beside or in addition to staying in or moving out of the property might help to satisfy you or the other party. Come up with a list of alternatives that both parties might agree on to avoid a trial, delays, and the possibility of losing or not collecting any money owed to you if you win. At the mediation session, be sure to present your side of the dispute clearly and listen carefully to the other party's point of view. Make suggestions for how to settle the dispute, but also listen openly to other ideas. Remember that mediation is about give and take. Everyone has their own point of view. Although you may feel like yours is 100% right, you may learn things that help you better understand the problem and resolve the dispute. If you settle your dispute in mediation, the mediator may encourage or help you to prepare a written agreement. This document should clearly explain what everyone has agreed to do. If the landlord hasn't filed an eviction yet, A court case usually won't be filed or become a court order unless someone does not do what they agreed. But if somebody does not do what they agreed, a case may be filed and the agreement may be enforced by the court. If the landlord has already filed an eviction case with the court, your agreement may be documented on a court form called a stipulation. The agreement or stipulation may be filed with the court and become an enforceable court order right away. Or you may decide that the stipulation will only be filed and become a court order if someone breaks the agreement. Many counties have nonprofit dispute resolution programs that provide free or low-cost mediation before or after an eviction is filed. To find a program near you, ask your court for a list of mediation programs in your area. Some courts offer free or low-cost mediation, either before the trial or on the day of the trial. Private mediators are available in many communities, and they often advertise in the yellow pages or newspapers or on the internet. Private mediators' backgrounds and fees vary considerably, so be sure to ask.